I'm Adam Liptak. I cover the Supreme Court for the New York Times, and welcome to what should be a very interesting session on disparate impact. It's a timely topic in the wake of the Supreme Court's recent decision upholding Michigan's ban on affirmative action. And I say that not because the question was particularly prominent in most of the opinions, but Justice Scalia's concurrence did both set out his own vision of what the law requires and say that the plurality he was concurring with had done a disservice to the Constitution on the question of disparate impact. So he said that the plurality endorses a version of the proposition that a facially neutral law may deny equal protection solely because it has a disparate racial impact. Few equal protection theories, Justice Scalia said, have been so squarely and soundly rejected, but he went on to say the plurality opinion leaves ajar an effects test escape hatch, say that a few times fast. So that really sets out the basic question we're going to explore, and we couldn't have better people to explore it with. We're going to follow the time-honored panel format with some opening remarks, a little back and forth between the panelists, and then plenty of time for your questions. We're going to first hear from Peter Kirsanow, who practices at Benesch, Friedlander, Coplan, and Aronoff, has served on the National Labor Relations Board and currently on the U.S. Commission on Civil Rights. Then from Gail Heriot, who teaches law at the University of San Diego and is also a member of the U.S. Commission on Civil Rights. And then from Ted Shaw, currently a law professor at Columbia and with a long and distinguished career at the NAACP Legal Defense and Educational Fund. Peter? Thank you.
Good morning, everybody. As usual, I'm disappointed that my introduction doesn't include my Congressional Medal of Honor and Heisman Trophy. Nonetheless, disparate impact. It is a matter of dubious constitutionality, dubious legal providence outside the area of employment law, is of profoundly misguided policy, and it's metastasizing. Aside from that, I think it's a wonderful concept. If you think about the constitutionality of it, as Adam just indicated, there have been a number of forays, usually in concurring opinions, and at least twice in the last 5 years by Justice Scalia, raising the issue as to whether or not the evident tension between the 14th Amendment and Title VII can be reconciled in favor of disparate impact. The manner in which Scalia couches it suggests that he doesn't think it could be reconciled in favor of the continued application of disparate impact as currently constituted, and that's for good reason. If you look at some of the majority opinions that have been issued over the last few years, such as Parents Involved versus Seattle School District, where it, not in and of itself, but it piggybacks on top of a couple of other cases, including Bakke and Grutter, which says that outright racial balancing is unlawful. And what is disparate impact other than outright racial balancing? Despite my astonishingly youthful appearance, I've been doing this for 35 years, and all of the employers that I represent are simply saying, how do I get my numbers right? They don't necessarily want to engage in quotas, they don't want to violate the law, but they don't also want to see the in front of the neighborhood EEOC person knocking on their door saying, let me look at your numbers, or your person from the OFCCP saying, look at your EEO1. How come you don't have 15 Martians in the professional category? Trying to reconcile the strict scrutiny standard of equal protection versus the Title VII's disparate impact is a challenge. Let's say for a moment that it is something that constitutes a compelling state interest. Whether or not this constitutes strict scrutiny is another examination altogether. I don't think it frankly satisfies either one. But if you look at the Ritchie versus DiStefano case, the firefighters case that I think most of you are probably familiar with, where the city of New Haven throwing out a firefighter's exam for promotional exam engaged in disparate treatment in order to avoid a disparate impact lawsuit, at least ostensibly. If you look into the record, there's some other political motivations behind it. But here we have a policy that encourages people to engage in disparate treatment to avoid disparate impact, unless they've got, sound, strong basis and evidence to do so. This really gets it backwards. In terms of the dubious legal provenance outside the employment context, we had Griggs versus Duke Power. Then after Griggs, we had Ward Cove Packing, at least a few years later. Then we have the 1991 Civil Rights Act that kind of restores the concept of disparate impact. Outside the employment context, you have to look far and wide to find any kind of statutory justification or case law justification in areas beyond the employment sector, yet we're finding it expanding to those sectors at warp speed. We see it in, a few months ago I testified before the House Banking and Finance Committee on HUD's application of disparate impact. In terms of housing, the Fair Housing Act, again, goes far beyond where disparate impact was thought to go or should be applied 40 years ago. I live in inner city Cleveland, but apparently HUD thinks that that's a choice that was just really bizarre. Why would I want to do that? Why would I want to live among other black people? It's really a real burden to live among other black people. But who, among all of the bureaucrats within the government, in Cubicle 14A over on Constitutional Avenue, gets to say where somebody lives or should live? Who comes up with this stuff? From a policy perspective, it makes little sense. At the Civil Rights Commission, Gail and I have seen disparate impact applied to a couple of other spheres. School discipline, the EEOC's criminal background check. The Consumer Finance Protection Bureau, for example, uses a disparate impact model in terms of lending practices and other things financial institutions do. There is not, I guarantee you, I promise you, there is not any standard, any practice, any policy in the history of the world that does not yield a disparate impact of some nature. Does that mean that was something that should have been outlawed when the 1964 Civil Rights Act was intended to be outlawed, when the 1964 Civil Rights Act was passed? Is that something that we should be doing today, 50 years after the 1964 Civil Rights Act was passed? Is a regime of quotas and proportionality something that we should be doing as a society from a policy perspective as a practical matter? In terms of bad policy, we can look at a couple of the outcomes, and I'll just raise two of them, and then I'm going to sit down and let the bigger brains address this. If you look at where it has kind of metastasized into, such as the EEOC promulgated a guidance a year and a half ago dealing with criminal background checks, whereby it made it more difficult. The EEOC would say, well, it's no change in policy, which is wrong. It is. It makes it much more difficult for an employer to credibly use criminal background checks because the EEOC says that, well, if you use a criminal background check, it's going to have an adverse, disparate impact on black and Hispanic males. Right, that's true. Felons are not a protected class yet, right? So what we do is we piggyback onto the racial protected classification to do this. I happen to think integrating criminals, former convicts into the mainstream of society is a good thing. But from a policy perspective, is it wise to use this vehicle to do it? And from a legal perspective, does it pass muster? Here's why I say it's policy misguided. EEOC rushed through this guidance with a minimal amount of scrutiny. By the way, query whether or not it satisfies the Administrative Procedure Act because the EEOC is not permitted to engage in rulemaking, substantive rulemaking. Yet the guidance has all of the indices of being a rule. Aside from that, let's put that aside for a second. EEOC rushes through this guidance that has a variety of factors using the green tests, but you have to have an individualized assessment when you are about to take an adverse action on behalf of an applicant who has a criminal background check that comes back and says, well, this is Charles Manson, maybe we don't want to hire him. You have to ask him, well, Charles, what have you been doing lately? Have you rehabilitated yourself? Don't want to make light of it, but when you take a look at what the EEOC did, and what they were trying to do ostensibly was to get former convicts into the mainstream of society, and particularly black and Hispanic males. What we found when we look at the empirical evidence is disparate impact actually harms the purported intended beneficiaries because what happens? We have found that an appreciable number, a statistically significant number of employers who aren't or don't avail themselves of criminal background checks are less likely to hire black and Hispanic males. And the reason for that is they resort to impermissible criteria in which to make their judgments when they're looking at an applicant for employment. If I walk in the door trying to apply for a job, and Adam walks in the door, regardless of whether or not somebody's biased or racist, guess what? The employer knows what the EEOC knows. That is, I'm more likely, despite the fact I look really tremendous and I look like an honest guy, I'm more likely to be the guy who committed a crime. So they're going to make a default judgment when they don't have concrete evidence as to whether or not I committed a crime. School discipline. The Department of Justice and the Department of Education now have issued guidances with respect to the imposition of discipline in schools, primary and secondary schools. Now we got to get our numbers right with respect to, who just beat up the teacher, who dunked somebody's head in the toilet, who discharged a firearm in a classroom. And we want to be very careful of making sure that Asians are disciplined as heavily as blacks. I'm exaggerating a little bit. But what happens in the real world is principals, administrators start to conform their behavior to the expectations of the Department of Justice and the Department of Education. Who does that hurt? It hurts the students in predominantly black and Hispanic schools who are there to learn and now have to sit next to the bad actors, who haven't been expelled, haven't been suspended, and are continuing to disrupt the class. Then take a look at, now it's been extended to the Consumer Finance Protection Bureau and other agencies. Anybody remember the Community Reinvestment Act? Be very careful when cavalierly applying disparate impact models on matters that really mean something, because dire consequences can issue from that. I'm going to leave it now to Gail, and I hope to talk to you further in the question and answer period.
Thanks, Peter.
Good morning, ladies and gentlemen. Pete has told you about disparate impact liability in employment law and about how it's being exported into housing, credit, and education law. I'm here to give you a little further background into this theory of liability, including a discussion of why, at least in the run-of-the-mill case, it's not just bad policy, but probably unconstitutional, as Justice Scalia hinted at in Ricci versus De Stefano. But let me first just emphasize a few points in case somebody came in late. The whole point of disparate impact liability is that it applies regardless of whether the employer, the landlord, the lender, whoever, intends consciously or unconsciously to discriminate. It's a wholly different theory upon which to predicate liability, emphasizing equality of results rather than equality of treatment. In the employment context, for example, if a particular job qualification, like a requirement of a high school diploma, has a disparate impact based on race, again, regardless of whether the employer consciously or unconsciously intends to target, say, African Americans, the employer must prove that it has a business necessity for doing so, and unfortunately, very, very high standard. The problem, of course, is that every job qualification has a disparate impact on some racial, national origin, religious, or gender group. As a group, men are stronger than women, while women are generally more capable of fine handiwork than men. Chinese Americans score higher on measures of mathematical ability than most other ethnic groups. Subcontinent Indian Americans are more likely to have experience in motel management than other groups. Unitarians are much, much more likely to have college degrees than Baptists. For years, I have been challenging my students to come up with a single, solitary job qualification that has ever been determinative of who actually gets or doesn't get a job that doesn't have disparate impact on some protected group. Even hiring employees whose surnames begin with an A. That will benefit Norwegian Americans at the expense of Chinese Americans. With the spread of disparate impact liability to housing, credit, and education, the same logic applies. Every credit qualification will have a disparate impact on some protected group. So no action can be taken without potentially getting sued, since nobody really knows what the business necessity or educational necessity, lending necessity, no one really knows what that standard means or what it will mean to the particular federal agency that's in charge of that particular statute. Everything is prima facie illegal. So the best strategy is keep your head down. Never, never, never make clear what your employment qualifications, credit qualifications actually are. The ramifications of this for the rule of law, to me, are quite terrifying. When everything is potentially illegal, political favoritism becomes the deciding factor. For what it's worth, it is pretty near indisputable that disparate impact liability was not intended by Congress in 1964. As civil rights movement historian Hugh Davis Graham put it, disparate impact liability, quote, would have been greeted with disbelief in 1964. Instead, disparate impact liability was the brainchild of EEOC lawyers attempting to turn what they regarded as a weak statute, Title VII, into a strong one. And at times, they were quite candid about that. Alas, the Supreme Court deferred to them in Griggs versus Duke Power Company, and eventually Congress acquiesced in this in their amendments to the Civil Rights Act in 1991. So it's the law with regard to employment. But why export such a wrong-headed idea to housing, education, and credit? Among other things, as I said, it is quite possibly unconstitutional. Strict scrutiny is a tough standard. Any law that is intended to confer benefits on a particular race or particular national origin group over another must have a compelling purpose and be narrowly tailored to serve that purpose. So far, no one has made a plausible argument as to how generalized disparate impact liability standards can survive strict scrutiny. The U.S. Commission on Civil Rights stated that disparate impact liability, quote, cannot be sensibly applied to white males, close quote. I will note that neither Pete nor I had anything to do with that statement. Given its purpose is to uproot institutional sexism and racism. In 1991, members of Congress stated over and over again in amending the Civil Rights Act that the law they were adopting was intended specifically to assist women and racial and ethnic minority groups, to give them a leg up. And scholars have agreed. Disparate impact liability doesn't apply to white males, although white males have been known to bring such cases. To my knowledge, none has been successful. Okay, if so, that's enough to trigger strict scrutiny right there. And one scholar has said that he used to firmly announce to his students that disparate impact theory is not available to whites and males, but he realized when the court began to make it clear that strict scrutiny applies on behalf of majorities as well as minorities, in cases like Grutter versus Bollinger, the court has said it. This scholar said he began to realize that in applying disparate impact theory, doing so one-sidedly would require that strict scrutiny be applied, and that, of course, would raise very serious constitutional difficulties. So he therefore urged reinterpretation of disparate impact liability to include white males. But for many reasons, that just doesn't work as a constitutional argument. For one thing, there's no evidence whatsoever that Congress would have approved. Suppose Congress passed a tax that applies only to Asian Americans, being quite clearly unconstitutional. The right thing for a court to do would be to strike that tax down, not to reinterpret it to apply to everyone without evidence that that's what Congress wants. Congress should make the determination whether or not it's going to apply to everyone. The same logic applies here. Moreover, a generally applicable theory of disparate impact is still racially discriminatory. The Constitution protects individuals from race discrimination, not groups. So if disparate impact theory is applied to help African Americans where they are underrepresented, but whites where they are underrepresented, that doesn't create colorblindness. That just creates twice as much discrimination. For example, imagine an individual, a white male, applying for a firefighter's job. as in Ricci versus De Stefano. It's not going to make that guy feel any better to know that the playing field would have been tilted in his favor had he been applying for a job with the NBA. He knows he's not qualified for that job. What he's qualified for is firefighting, not the NBA, so it doesn't help him. So in the absence of a compelling purpose and narrow tailoring to fit that purpose, disparate impact liability would have to fail. So in 1991, did Congress make an argument as to why this would survive strict scrutiny? No, it did not. It did not even attempt to offer a reason. And I am dubious that such a reason can be offered. With other statutes in play, again, housing, credit, there's no evidence that Congress intended disparate impact liability at all, much less that it believed that strict scrutiny could be overcome. So the efforts of scholars to come up with something that would save disparate impact liability have left a lot to be desired. Professor Richard Primus suggests the argument that disparate impact doctrine could have been regarded by Congress as, quote, a prophylactic measure necessary because deliberate discrimination can be difficult to prove, close quote. That's Professor Primus. Ultimately, despite Primus's view that this would be normatively desirable, he likes disparate impact liability, he concludes that that justification would fail, and I agree with him. First of all, it does not describe the actual motivations of Congress in 1991, but moreover, it cannot account for the current allocations of burdens and defenses. Defendants would have to be given the opportunity to prove that they were not, in their case, motivated by intentional, conscious or unconscious, intentional discrimination. Without that, I think this justification simply fails. Congress would need to revamp this law extensively in order to fit this very square peg into that round hole. So that one doesn't work. So what about other possible justifications that might survive strict scrutiny? Some have suggested that the need for the integration of the workplace, the need for the integration of schools and such would be a potential compelling purpose. But I submit that the evidence that this doctrine has systematically helped integrate minority groups into the economic mainstream is thin to non-existent. Some scholars have argued, in fact, and this is not simply conservative scholars, that disparate impact liability in the employment context has made employers more reluctant to hire minority employees because disparate impact liability makes firing very difficult and makes demoting very difficult and very risky as well. So there is certainly no showing that disparate impact liability has actually served the purpose of integration, much less that it is narrowly tailored to that purpose. Now, if we want sclerotic labor, housing, and credit markets where anyone who dares offer a job to anyone, who dares rent an apartment or lend money is presumptively violating the law, then this sprawling and incoherent doctrine is working just fine. But if that's not what we want, I think we need to beat a very hasty retreat.
Thank you, Gail. I wonder, Ted, if you've heard anything that gives you pause.
Pause. First, let me say I'm glad once again, in a very masochistic way, to be with you at the Federal Society Convention. I've really come to understand another element of my personality that I wasn't aware of at one time. But I am glad to be here for a number of reasons, including the fact that I think that we are all better off when we are in dialogue with one another. A discussion which is totally one-sided, no matter which side it's on, is an impoverished discussion. So I'm happy to be here, and also it helps me to keep my wits sharp. Thank you, Peter, for your presentation. I was sitting here and I was thinking, I know it was offered in humor, but here's a man who loves himself, and that's a good thing. I think there's something for me to learn from you. Gail, it's always good to be with you. You know, we were saying that we ought to engage in a traveling road show. Let me talk about what disparate impact is and what it isn't, because there's a lot that's been thrown out here that I think is tumbleweed. We can clear off the table. You know, there's all kinds of observations about disparate impact, and people are frightened about its implications. You know, it's terrifying. It's actually a much more modest theory than I think it has been described to be. The origins of disparate impact in the 60s and the early 70s did include an evolution, but that evolution has now, if it was in doubt, been put to rest both with respect to Congress in 1991, if not before then, but also by the Supreme Court, at least up until now. And one should be clear about this. One of the things that the Federal Society, I think, embraces is judicial conservatism. And so it would be anything but judicial conservatism to have the disparate impact theory declared unconstitutional. This is well-settled law. And we also need to distinguish between strict scrutiny and the constitutional standard that applies to the 14th Amendment and disparate impact. These are two different things. They operate in two different spheres of law. A conversation such as the one that we just heard, I submit, which is arguing, if I understand it correctly, that disparate impact is per se unconstitutional, is a convoluted discourse. It is a gratuitous discourse, and I think it's profoundly misplaced. So in the aftermath of the era of Jim Crow segregation, and I always remind people, and I take the opportunity to remind people about this. I don't shrink from this. I think people need to be reminded about it. That era didn't end eons ago. It was part of a continuum in what's now the United States that stretched back to slavery in 1619 right on up through the end of the 1960s. And what ended it in part was some of the legislation and the very case law and the theories that we're talking about. So the point that I'm making is that we really have to look at the continuum as going up until about 1970 of Jim Crow segregation. You know, Griggs v. Duke Power Company was in 1971. There you had an employer that was using a test for employment, and the test was totally unrelated to the job that needed to be done. You know, one can say that employers ought to be able to adopt whatever standard they want, but if it's not totally unrelated, then they ought not be able to do that. Now, to get inside their minds and prove that they were racially discriminatory, unless they were incredibly inept or stupid, becomes more and more difficult to do because people know better than to say the things that they once said. And the Supreme Court decided Griggs v. Duke Power Company, and it makes sense. This is not senseless jurisprudence. Where you have an employer who gratuitously adopts a policy, a practice, a standard that fences people out, and it has impact on people who have been fenced out historically, who have been the victims of racial discrimination, Why would you want to embrace that policy? Why shouldn't the employer have to articulate why that policy is necessary? And to cease using it, you're not even necessarily saying that the employer is wearing horns on its head, but you're saying this is not good policy. It unnecessarily fences people out, and it ought to be abandoned because you can't justify it. That's all it's saying. And for us to talk about this as being terrifying, I think is profoundly misleading and misplaced, as I said a moment ago. So Griggs v. Duke Power Company simply requires employers to show that the standard, the application, the policy that's being used is job-related, and it's necessary for the job. If it isn't, throw it out. Is that a radical concept? I don't think so. I would suggest that it isn't. There's been much said this morning in the little bit of time we've been here already that I think is also misinformed. If one really understands the Fair Housing Act, passed in 1968, finally after the assassination of Martin Luther King Jr., one understands that the legislative history of the Fair Housing Act talks about an affirmative effort to bring about integrated living patterns, okay? That's not talking about showing that people are engaged in racial discrimination because they have evil intent. It's an affirmative charge to change the country given what we know about racial integration and what we know about racial segregation. I'm puzzled. I'm genuinely puzzled when I hear people talk about this as being somehow racially discriminatory. Peter, with all due respect, like you, I have lived in all black neighborhoods by choice. I mean, I lived there for a number of reasons. I wasn't really thinking about, the fact that I didn't want to live with people who were not black. I've lived in all white neighborhoods, or virtually all white neighborhoods also. That's not what's at issue here. And to suggest that this is about making judgments about living in those neighborhoods in the way that you've articulated, I think, kind of misses the point. The Fair Housing Act has had an effects test applied by every circuit court that interpreted the Fair Housing Act. Every circuit court interpreted to have an effects test. Congress has left that standard intact. Again, this is not about so-called reverse discrimination. It is about an affirmative duty to further, where it's possible, integrated living patterns. If you think that's a bad thing, then maybe you come after the Fair Housing Act and the effects test. If it doesn't, then I'm puzzled about what your problem with it is. I know what the boogaboo is that's been thrown out here today. It's quotas. It's about, employers being afraid, this is an ironic one to me, to hire racial minority group members because they're afraid they can't fire them. I'm not going to even dignify that. I mean, I know that you can find scholars who have looked at all kinds of issues, but if those employers are, I'm not saying some employers may not think that, but they need to go back and re-examine both the law and also what they have, what they're thinking about if they make that argument. Here's the point that I want to make before sitting down. The EEOC put out this guidance, and you've already heard what's been said about it, because we know that there's massive over-incarceration. Maybe not everybody in this room will agree with that description, but more and more people who are thinking on all sides of the ideological spectrum have come to that point. Massive over-incarceration of people of color, particularly African American and particularly African American men. Let's be clear. People who are violent, I shouldn't even have to say this clearly, they break the law, they need to be punished. We're talking about people who have been incarcerated, who have paid whatever debt they had to society, and we're talking about the fact that disproportionately many African Americans are incarcerated for crimes that people who do the same thing, who are not African American or Latino, are not being incarcerated, or they're being given shorter sentences, et cetera. There's a civic death that's been going on in all kinds of areas. I'm not here to talk about all of that today. What I'm saying is that if employers, using Griggs v. Duke Power Company, have a job-related function that justifies keeping somebody who has a felony record out of that job, then it makes sense to do it. If it's unrelated, then it doesn't make sense. And I'm certainly going to be an advocate for what the EEOC is trying to do, because what it's trying to do is make sure that people are not fenced out because of a felony record that's unrelated to doing the job that they need to do. Obviously, you don't want people who are child molesters and who have been convicted of being a child molester teaching children or working in nursery schools. Nobody is arguing about that fact. This is a much more reasoned standard, or reasonable standard rather, than has been articulated. Finally, let me just share a quick story that shares my view about disparate impact. I remember I started out at the Justice Department years and years ago, and when I was there was a case that some lawyers wanted to bring that would have gone after a suburb of a large city for minimum lot size ordinances because they had disparate impact. Not surprisingly, given the wealth difference between racial minority group members and white Americans. That case was rejected. This is under a Democratic administration, under the Carter administration. It was rejected, I think, for good, sound reasons. I've always viewed the disparate impact case as a kind of a lower threshold. Race is in the air. You can smell it. Maybe you can't. You don't have all the proof that would satisfy an equal protection clause claim, but in some instances there are statutes in which Congress is saying you don't need that. And so it's a much lower threshold. In some instances it makes sense, but it has to be applied in a very reasonable way. So it's not the great evil with terrifying consequences that we've heard described today, but it is in the gun sights now of a certain group of conservatives, folks on the far right, and they're trying to get rid of the effects test under all circumstances. And I realize that, some of you in this room, you disagree with me, as you're welcome to do. I have come to believe for a long time now that there are two types of conservatives in my view. One is the type of conservatives, people who are intellectually and instinctively conservative. I welcome discourses with those folks. I respect that kind of discourse and respect folks who have those views, even if I disagree. And they help make me better also. Then there are people who are ideological conservatives. I don't respect that. And I realize that many of you in this room could say the same thing about folks who are liberal or progressive, etc. That's a fair argument. I encourage you to be the first, not the second kind. That's presumptive, and I know I'm in the lion's den, but that's what I came here to tell you.
Thank you very much, Ted. Thank you, everybody, for those excellent presentations. I think these issues are joined. They're not particularly new. As Ted says, the question is in the gun sights of many conservatives, and he didn't say so, but some of those conservatives sit on the United States Supreme Court. And I want to ask the question, looking forward, about why it is, given that, that we're not getting answers from the Supreme Court, and how much of it turns on the availability of plaintiffs, the settlement of lawsuits even after cert is granted, and how do we get an answer to these questions out of the Supreme Court? Maybe I'll start with Peter.
Well, I should think you hit the nail right on the head. We had Taxman versus Board of Education, settled. We had Mount Holly. We've had some other cases that have had kind of peculiar genealogies. They seem to just kind of disappear for whatever reason. I think that there is an understanding on the part of some on the left that if this Supreme Court had the ability to entertain a clear challenge to disparate impact, that doctrine would have a very, very short shelf life. So I don't know when the Supreme Court will have an opportunity to directly address the issue, because I think whenever a case comes up, it seems to disappear before the Supreme Court can actually pronounce upon the matter.
Ted, how can you illuminate this issue? Do you think there's, is there anything amiss with the sense that civil rights groups are trying awfully hard not to get a decision in this area?
Well, you know, when you have folks, with all due respect, you know, to Gail, who say that that these standards mean that everything is prima facie illegal, you know, first of all, that's not true. That's not what the argument is of folks who support disparate impact. But if that's the view, and if that's the view of people who are on the bench, I don't want them deciding these cases if we can keep them away from them. You know, it's no secret, you know, it's no secret, certainly to people in this room, that this is a court, although it's very narrowly divided by one vote, for the most part on these kinds of issues. This is a court that is pretty hostile to the established corpus of civil rights law. You know, this is a court that found voluntary school desegregation efforts to be reverse discrimination. You know, I still sputter about that because, you know, it's a court that claims to honor Brown versus Board of Education in practice, but in theory rather, but in practice dishonors it. So we don't want these issues before the court, clearly. In addition to that, and I tell you this is a civil rights lawyer who's been around the block for a long time, you know, like Peter's, I think you said 35 years, and you and I are about the same vintage. You know, in many instances, we've seen cases that go to the court that those of us in the civil rights community would not support. That is to say, we think that some of the institutions that bring these cases to the court may not have the understanding that we have of how these things should work. So if they come to the court, I said many instances, in a few instances I can think of, if they come to the court with these cases, you know, and we can do anything to get it out of the court, we're going to do it. And we should be able to do that. And folks on the other side do the same thing. I'll give you a quick example, if I may. Do I have a moment? So some years ago, the case that came to the Supreme Court out of the Piscataway School District, which involved a white teacher who had been laid off. And she was told she was laid off because of affirmative action requirements by the Piscataway School District. They had to lay off somebody, and they said it came down to a black and a white teacher, Sharon Taxman, the white teacher, Deborah Williams, the black teacher, who were both hired on the same day, and they deemed them to be equally qualified. Well, I think everybody in this room can understand that no two people are exactly the same. These two people weren't, and they could have decided this on any number of grounds, but they decided that they had to apply a heretofore unused affirmative action policy. And they fired Sharon Taxman. They shouldn't have done it. If they had come to me, I would have said, don't do it. The Supreme Court had already said in the context of layoffs that layoffs using race was a no-no. It was a third rail. So, you know, their lawyers should have told them, don't go near this, and they did it. Now, people outside of the civil rights community may put this on the civil rights community. You know, I work for the organization that did more civil rights litigation on behalf of African Americans than any other. And we would have said, don't do it, but they did it. The short of the story is, and it ended up going to the Supreme Court after decision by the Third Circuit, as many of you know, which said that not only could race not be used in that context, but it was improper to consider race in an employment context outside of a proven violation, period, which would have ended up ended all voluntary efforts to engage in hiring and diversity, et cetera. Did we work to get that Supreme Court case out of the Supreme Court? Yes, we did. Was it unprincipled? Was it wrong? No, I don't take that view and don't accept it, even though we were harshly criticized. And I would take any other case that comes to the Supreme Court because somebody misapplied the law and sets up or puts at risk the corpus of civil rights law that rightfully engages in efforts to build an inclusive society. I try to get those cases out of court any day.
So I'd love to get Gail's reaction to that, and in the meantime, if you guys have questions, you can start thinking about them and lining up.
Well, I think the basic question you've asked has now been answered, that, yeah, this thing does seem to not make it to the Supreme Court. I would like to see it make it to the Supreme Court. I don't think that it's any kind of violation of ethics in the abstract to settle a case, even though the court has accepted it. I don't like the idea of the Department of Justice being the driving force in these kinds of settlements. I think that's inappropriate, but I don't think there's anything inappropriate about private organizations seeking to facilitate a settlement in order to keep a case away from the court. I don't think that's a problem.
Thanks. Roger?
Yeah, I wanted to follow up on that and ask for the other panelists also to opine on at what point there might be ethical problems with settling a case. I mean, Ted, you started out and I thought you were going to give a counterexample of somebody on the right trying to keep a case out of the Supreme Court, but you just gave another example in the Piscataway case of another example of the left trying to keep a case out of the Supreme Court. And I'd like some more, discussion of that. And I also wanted to ask Ted if he would be in favor of codifying at least an affirmative defense in disparate impact lawsuits, so that if the defendant can get it on his own mind and prove that he did not act with discriminatory intent, whether that should be allowed as a defense in a disparate impact cause of action.
Let me answer the first question, the last question first. I don't think that intent, and maybe I wasn't clear enough, racially discriminatory intent doesn't have anything to do with disparate impact theory. It's two different theories. As I said, mixing these theories and coming at disparate impact theory because of the standard that applies to equal protection is muddying the waters. It's convoluted. It's not clear thinking. Whether it's accidental or not, I can't tell you. But one has nothing to do with another. And so, again, I can't begin to understand why is it, let's start with the presumption, which is where we all ought to start, of good faith, that people disagree about these issues in good faith. But why is it then that if you have a theory which says do no unnecessary harm to people who are disadvantaged, who have been excluded for one reason or another, you can adopt a theory, you can adopt a practice or a set of practices that don't do harm, and it doesn't do harm to those individuals, and it is unnecessary for the employer to adopt those standards because it's unnecessary, it's not needed to do the job, etc. Why wouldn't you adopt that? I'm long puzzled by why it is that many people on the right, and forgive me for this, but I'm going to articulate it because I don't get to see you every day, why it is that just about every theory of aggressive application of civil rights law that ends up with more inclusion is inconsistent with your view. This is not a theory that is outside the box, or shouldn't be. And so don't confuse the two theories. With respect to settling cases, Roger, and as I get older, my hearing gets worse. And so you'll be done with me probably in a few years because I won't be able to engage in any discussions, I suppose. But look, the bottom line is this. In cases like, the housing case that was before the Supreme Court last term, where you had landlords trying to use Title VIII in a way that they thought protected their interests. Again, those landlords are not part of the civil rights community. They don't understand Title VIII law, and what they were doing was problematic from my perspective. that case shouldn't have been at the Supreme Court on that theory. Maybe we would agree with that, with each other on that. And so, should that case have been in the Supreme Court, in my view? No. Could it do a great deal of harm and damage to what I would describe as legitimate Title VIII enforcement efforts? Yes. Should we sit by quietly and watch the court decide that case? Bad facts make bad law? No, we shouldn't. And so again, I'm unapologetic about getting those kinds of cases out of the Supreme Court, and there's nothing unethical about it. I challenge you to tell me what the ethical problem is. It happens in the business community every day. Cases that are bad cases, if they can get them settled out of the Supreme Court, they do it. I'm sure I'm not asking Adam because he's not here as a panelist, but I know he's seen this in other contexts and other cases. So nothing unethical about it. It's necessary. Sooner or later, I'm sure the court will take one of your cases and maybe make you happy.
Gail and then Peter.
I just want to make a point about this notion of why shouldn't employers be happy if all they have to do is justify that what they're doing is reasonable to the federal government. I mean, why is that such a big deal? We all want employers to be reasonable. We should want everybody to be reasonable. But when I discuss this with my students, sometimes I put it this way. I ask them, well, at the end of every day, if you had to justify the reasonableness of every decision that you made that day to some bureaucrat somewhere, would that be a good thing or a bad thing to you? I mean, could you actually justify everything that you do? Can you demonstrate to some inside the Beltway bureaucrat that the decisions you made, like the law school that you chose to go to, can you justify that? Can you justify the people that you decide to study with? Can you justify that to somebody out there? And the answer is, nobody in the world can justify every decision that they make to some strange bureaucrat or to some court somewhere. That basically is not the way to get people to be reasonable. And if we did have to justify every decision we make to a bureaucrat, would that make those decisions more reasonable, or would it simply make them more bureaucratic, more play it safe, less creative? If we want to have a sclerotic economy, the best way to do it is to say, from now on, we've all got to be able to justify every decision we make in hiring, firing, promoting, all of these things. And yet that's what disparate impact liability does. It makes people justify every decision that they make.
Absolutely
and
not.
I would be absolutely stunned if anybody really thinks they can do that and that their decisions would be better. We live in a world, I think, where most decisions get to be made by the individual employer, the individual lender, not subject to government supervision. And it would be a much worse world if we did have to submit ourselves to supervision, and I would submit not a more reasonable world at all, but rather just a more bureaucratic world.
I'm eager to get to a couple more questions. Peter, a quick reaction?
Yeah, real quickly. In response to Ted's question about why certain conservatives or conservatives are supposedly opposed to aggressive actions that result in greater inclusion, I'm not sure that conservatives are opposed to aggressive actions that comport with the Equal Protection Clause. I would submit that this type of aggressive action doesn't comport with the Equal Protection Clause. The reason why conservatives are opposed to some of these types of actions is something called the Constitution, and one of the reasons why we oppose it is because the Supreme Court, Congress understood that the issue of race is so fraught with peril that we have the highest standard in civil jurisprudence, strict scrutiny whenever you engage in racial classifications. And when we deal with disparate impact, we're necessarily dealing with racial classifications that have dubious, whether or not it satisfies a compelling state interest, but is not narrowly tailored also. I would submit to you that one of the reasons also we would oppose it is because we look at the empirical evidence. You posed that you're opposed to ideological conservatives. I'm opposed to fuzzy, muffled thinking. Not yours, I'm not saying that, but I'm anti-fuzzy, muffled conservative. When we look at the ramifications, aside from even the Equal Protection Clause, of disparate impact, we have to ask ourselves, where is the empirical evidence that it has actually done a salutary service to the issue of equal protection? Second, when you look at the inherent wrongs that have been done, when you look at, this is the cousin of affirmative action, where now we have a copious amount of empirical evidence with respect to the effect of the mismatch theory. In disparate impact, what we're seeing is, and we've seen it in hearings before the Civil Rights Commission, that again, the EEOC background check policy actually causes employers to be less likely to hire black and Hispanic males. School discipline hurts those who are trying to get an education, and you go down the line. And who is the racial engineer? Who is the omnipotent racial engineer among the federal bureaucracy to whom we give this charge to manipulate all of this and say, 20% black here, 5% Asian here is the right way to go? I don't trust anyone to do that. I trust the Constitution to mediate this to the best of our ability.
Yes, sir.
So
I'm sorry. Hang on one more
very
second.
quickly. There's some words that are trigger words, and I'm not trying to respond to all of them today. I'm just going to identify them. You know what they are: quotas, bureaucracy, bureaucrats, etc. I understand. Immediately you get your back up. You're opposed to that, and everybody shares frustration with bureaucracy, etc. They can obscure what we're trying to get at here, I think. It is a very popular argument these days, and we're not here to get into a mismatch theory and all of those issues. Gail and I mixed it up on that recently, and we'll mix it up on that again. But it's a very popular theory these days, and it's being used more and more broadly to argue that policies and practices that are meant to open opportunities to people of color, racial minority group members, etc., actually harm them. I'm just flagging that, and we can set that up for another day and another argument. So I just wanted to point to those things and flag them, and maybe we can have those discussions on another day. Again, disparate impact theory, 14th Amendment, equal protection. We'll get to you. Hold on a minute. There are two different theories. I just underscore that again.
Hi. I want to explain some historical background on discriminatory impact on some areas that people are not aware of, and how it impacts on some of the issues. In 1972, the federal government decided to evaluate the economic discrimination in the United States. The White House created a special task force, and that was kind of the origin of the concept of a discriminatory impact and how it was to be used. And the general idea was the discriminatory impact was to be used across all areas where it has economic impact, not just employment. I was hired by OMB, by then Dr. Kirsanow, who many of you may know, who worked for Cato, to be the person responsible for evaluating how the federal government worked and what was its impact on discrimination across all kinds of economic issues. I evaluated the EEOC, the Office of Federal Contract Compliance, the civil service, and a wide range of other areas.
I don't want to interrupt, sir, but if you could drive to the question.
So what key issue on discriminatory impact was that you have a kind of a multivariate factor analysis where you find a discriminatory impact and you try to identify the factors involved, and that's where people sometimes fail. But often it is impossible to identify the relative importance of each factor, and so you look into alternative, suitable, reasonable implementations. And I think that's where, if I understand Professor Shaw, that's the key issue that was not quite addressed. It's not that every factor is appropriate, but only has to be a substantial factor, and there has to be no suitable alternative. So that, I think, goes to the issue of whether any decision is subject to discriminatory impact. I would like you to see.
I agree.
Thank you. Why don't we take that in the spirit of a comment, and we appreciate it, and move to the next question.
Hi there, Lisette Garcia, owner and director of the FOIA Resource Center, 2008 graduate of Howard University School of Law. We studied disparate impact there quite a bit. I guess my question has to do with Magna v. Gallagher. You weren't able to hear me?
We're having a hard time hearing
Sorry
you.
about that. I didn't want to speak too loudly. Lisette Garcia, owner and director of the FOIA Resource Center, 2008 graduate of Howard University School of Law. where we studied disparate impact in every single context, from contracts to real estate to professional responsibility. My question has to do with the Magner v. Gallagher case that was brought up. We didn't refer to it by name, but we did discuss the case that went before the Supreme Court. Are you still not able to hear me?
Yeah,
I'm sorry.
Yeah.
Could you step a little bit away from it? Because
It sort of sounds like you're underwater. I don't know what it is.
Sorry about that. Is that
Yeah.
better? I think maybe.
It's-
Yeah, it's not your fault. It's just, it's not working very
I
well.
think maybe he turned it off, is what it is.
Maybe you could just speak loudly.
Okay, that's better.
That's
Yeah.
much better.
I mean,
Okay.
I can project just fine.
Thank you.
So anyway, so Lisette Garcia, owner-director of the FOIA Resource Center, 2008 graduate of Howard University School of Law. We studied disparate impact in every single context, from contracts to real estate to professional responsibility. The panelists referred to the case that went before the Supreme Court last year and was ultimately dismissed by mutual consent, the Magner v. Gallagher case. We didn't
Yes.
know that by name. My question would be, you said, Mr. Shaw, that you'd be happy to see, bad facts make bad law, and so it's important to keep those kind of cases out of court. And you said that they try to use it, these landlords try to use it falsely against themselves. In fact, just to kind of give everyone a background, it was really that they were resisting over-enforcement, aggressive enforcement by code enforcement, that were later found to be corrupt and pocketing some money through a chain of events. My question would be, what is the propriety, two questions really, what is the propriety of the dismissal in trade for having the city withdraw its case from the Supreme Court? Isn't it the case that DOJ made a Keaton whistleblower case go away, where HUD had not been enforcing grant provisions, millions of dollars over the course of several years? There was a quid pro quo. If we make this Magner v. Gallagher case go away from the Supreme, if you make this Magner v. Gallagher case go away from the Supreme Court, we will forget about all the grants we've given you that you have to reimburse, and we won't fine you for violations of those grant provisions. So what's the propriety in that to really rape the public fist in exchange for, we want this law to be so we're going to jimmy the system? And then the second part, what's the propriety in telling me where I have to live? The underlying notion, too, that's more of a policy argument, but you raise the issue that, what's wrong, that's your brother who is, racially, socially engineered. I should be able to live where I want to live. I went to Howard University School of Law precisely so no one could ever say I got in on a quota. That determined my choice. Quotas caused me to choose a school based on, I never wanted anybody to think I got it just because of a quota. And so I agree with Mr.
Kirsanow.
Kirsanow.
And the comments he made, it governs Congress. So those are the two questions. Thanks.
Well, let me say this, and I'm not trying to.
I would really like to hear from the other panelists, honestly.
Oh, well, okay. I completely agree with you. The Department of Justice's handling Magner versus Gallagher was just plain inappropriate. The Department of Justice should not be trading one violation of the law against another, and that was a very disturbing case. Insofar as the Department of Justice had anything to do with the settlement of Mount Holly, I'm not very keen on that either. My point earlier was simply that an organization like the NAACP Legal Defense Fund encouraging a settlement of that kind, that doesn't bother me. That's just a private party going in and saying, we really think you should settle this case. We think this is, a better outcome. That's fine. But when the Department of Justice gets involved in this, particularly when it's trading one violation of the law off for another area of the law, that's just creepy.
Ted, you're free to speak, notwithstanding what the questioner was.
I sat back for a moment to be respectful, although, well, I'll just leave it at that. I'm not privy to all that the Justice Department did. I was really talking about what the Legal Defense Fund has done in getting these cases out of the Supreme Court and saying, I don't see any ethical issues here, and I don't back up from that. I'm going to be presumptive. You may not want to hear this from me, but I'm sorry to hear that you chose a law school based on your fear of being labeled as a beneficiary of a quota. But that's what you decided to do. It's unnecessary, was unnecessary. I hope you had a good experience at Howard Law School.
It was awesome. They taught me that you were saying is untrue.
Pardon me?
They taught me that the ins and outs of disparate impact we talked about every day, and a lot of what you said today is untrue.
Well, we can have some of this conversation
Yeah.
afterwards. Done. Next question.
Can you hear me?
Yes.
Mr. Shaw, you had mentioned earlier the 1971 Griggs case, and I had a related hypothetical. Suppose you have a hotel like this hotel, the Mayflower Hotel, and they hire lots of people, front desk people, concierge, but they also hire people to clean rooms. And it may be such that the people who clean rooms, they get very nice salary, very, very generous benefits, and as a result, they have a flood of applicants. And then, you know, they have to make a decision, and they say, well, maybe we need to winnow it down, and they require all people who want to clean rooms to have law degrees. It seems strange and maybe a bad policy, but I'm just curious, why is that unconstitutional?
Okay. Now, again, I mean, can you
There was a key phrase that we missed. What was the what was the
I
qualification?
don't know what it is about that mic, but it's doing something. It's
Yeah.
swallowing some of you.
Yeah.
I think we got most of it. So people are applying for a job at a hotel, and the employer does what?
Yeah, they, because of the generous salary and benefits, they have to come up with some other criteria to, you know, narrow the number of possible people to hire. And they require that all people who want to clean rooms to have law degrees. Now, it may seem like a strange policy, and it clearly is unrelated to the task, but I'm just curious why in that situation that policy would be unconstitutional. We would agree it's bad policy, but why is it unconstitutional?
I'm still not sure I understand it, but the,
So,
you get
an ordinary hotel job
Yeah.
that pays very well,
Yes.
the employer says, in order to get the job, you must have a law degree. What's unconstitutional about that?
an ordinary job?
Yeah,
That maybe what I misunderstood, because it doesn't seem, I haven't heard anything about job relatedness, that why
Right.
it's necessary to have a law degree in that job. And if it, I'm not saying it's unconstitutional. I'm saying, you know, I wouldn't say, I don't see a constitutional question there. It's a private employer. Whether it should be illegal or not, if it has some disparate impact that falls on groups that are protected by Title VII, I would say that then it should be illegal. Even if it's not a protected group, I think it's incredibly bad policy, and I would want to think about, you know, whether or not there are any reasons to get them or any handles to get them to stop the application of that policy.
Yeah, I agree that it's questionable policy. This is a question of whether or not you're saying it should be illegal. I mean, is it unconstitutional, or is it just a wish list that it ought to be illegal?
It may or may not, excuse me, it may or may not be a violation of Title VII. I'd have to know more. I don't see a constitutional question, though, in that hypothetical.
Look, under disparate impact doctrine, it probably would be considered illegal because it's not job-related. They'd be able to demonstrate that having a law degree does not necessarily make you a better, whatever it is, someone who cleans rooms. It's not necessary to do that. And to your point, again, who is this omniscient bureaucrat who gets to decide on the part of private employers that this is not an acceptable job criterion? Who is that person? You know, I guess we have a bunch of people in the bureaucracy, sorry for that term, who've got IQs of 200 who can make that determination for all the discrete employers throughout the country. Griggs versus Duke Power was an attempt to ferret out intentional discrimination. It was pretty clear what was going on there. If using disparate impact was a tool like any other evidentiary tool related to the preponderance of the evidence, then I might be persuaded that that's something that should be used as one piece of evidence to show that a discriminatory practice was indeed something that was in violation of Title VII, subject to, as Roger indicated, potentially an affirmative defense. We've got it kind of backwards, where the presumption is you didn't do it the right way, and therefore you are guilty until such time as you can prove in a way that would never satisfy a Daubert standard that you have a business necessity to do it this way. An impossibility. Again, I do this in the real world. The employers that I represent tons and tons of redneck racist employers. Every single employer is a racist. Those guys out there are out there trying to make widgets. They don't care if the guy who makes widgets is black, white, or green. Understood. We have racism in society. That is true. But we've got a multi-billion-dollar apparatus to address that. And it works fairly well, and I submit to you it would continue to work if we take out of it the current iteration of disparate impact theory. But the whole job-relatedness thing, consider, for example, the idea of having a law degree to clean a room. The bureaucrats, again, have this sense of the job market that everything is static. In other words, all right, it's unnecessary to have a law degree to clean a room, but many employers would like to have a certain standard, such as having a law degree, maybe something not that elevated, although I don't know how elevated a law degree is,
These
but
days?
some type of a standard so that the employee who comes in at the ground level shows the ability to move up to higher levels. He wants to be able to have that standard as a measuring stick. He doesn't intend to keep that employee in the entry-level job. But the bureaucrat doesn't get that because he's going to be in his cubicle forever.
So we're out of time, but you've been so patient. Why don't we do a quick one?
It's a quick question, just for Professor Shaw. I just wanted to know your take on the holding in City of Jackson that said if a statute like the FHA lacks affects language, then it cannot encompass disparate impact. Just wanted to know your take.
Okay, so I haven't focused on it, to be honest with you. So I'm not prepared to answer it, but I can have another conversation with you right after this and give me a little bit more information. Okay? My apologies.
Please join me in thanking the panelists for a very lively discussion.
Thanks, Adam.